Okay, I'll offer that to Mr. Stenberger.
First, I want to respond to Derek's comments. Michigan, these other states he's pointing to, they have different language. Okay, you can't just look at other states. You have to look at the specific language. And here in Florida, the specific language has been approved by the Florida Supreme Court. It mirrors the language of the current marriage laws on the books. And the substantial equivalent language just says, hey, even the professor agrees with me, and she's a neutral person, saying that these are not going to invalidate domestic partnerships. We cataloged every domestic partnership. There's 21 of them. They grant a small bundle of benefits like burial rights, the rights to visitation in hospital, rights to visitation in prison, those kind of things.
But
it's about 6 to 9 rights. It doesn't approximate the 1,000.
Health benefits is one of the sticking points of domestic partnerships, though, isn't it?
Some counties grant health benefits.
Okay, so Cynthia, these other states, Ohio, Kentucky, and Michigan, where the ban has been passed and it has been challenged, gay and straight domestic partnership benefits, that is a different scenario than what we're looking at in Florida, potentially?
Well, I'm here to look more at how the amendment would, whether the amendment is has been appropriately brought to the public. And my thought is that as far as how the other states have treated it, their language is different. It's not exactly the same. And also, to even bring this to the ballot, it has to involve only one issue, which it does, and that the ballot description has to be straightforward and not misleading.
So let's say it has been appropriately brought to the ballot. Do you believe that it opens the door or not to legal challenges to gay and straight domestic partnerships as they sit right now?
In my view, as reading this, the ballot summary and the full text, which is a sentence, no, I do not, because as a family law professor, and that's my specialty, a civil union is expressly different, which we're not talking about, expressly different from marriage, gives less benefits, and that a domestic partnership gives even less benefits to the parties than a civil union.
So they're saying it's not the substantial equivalent of a marriage.
Well, the bottom line of that is that's going to be determined in court. I mean, that's part of the problem with this amendment is if it gets put into the Constitution, you can time it with a stopwatch. A lot of people, and again, the legislature says the cost of litigation will definitely increase to the state having to defend this if it gets in the Constitution because it will be challenged. And even though the language isn't identical, you don't have to look much farther than, like I said, Michigan or Ohio, for example, where a similar amendment, again, not exactly the same, but a similar amendment has been used as a defense against domestic violence, where somebody who had abused his live-in girlfriend said, you can't recognize our relationship.
No, that's outrageous.
Well, let me